And together with, my name is Chris Bentley, and together with Hirsch Perlis, we co-founded the Legal Innovation Zone 7.5 years ago. We support entrepreneurs looking to build the legal services that consumers need. We engage in initiatives supporting institutions, public and private, who have a legal innovation agenda. And we engage in projects like this to help modernize the legal system, make it work for the people it's supposed to work for, the people of the jurisdiction that the courts serve. So today is a launch. It really is a soft launch. It's a launch of a 3-month project, which will conclude on March 3rd with a conference. Our plan is to make it a hybrid conference, which will bring together what we do between now and then, and will help crystallize a number of the thoughts for rebuilding courts. So what do we mean by rebuilding courts? And thanks all for joining us. We're not talking about getting out your trowel and the mortar and the bricks to build a court such as you see over my shoulder. We're talking about making our court system, which is the foundation, not just of our legal system, but of our democracy. Making our court system work better for the people it's supposed to serve. The people of the jurisdiction. In my case, Ontario and Canada. You may be joining us from outside of Ontario or outside of Canada. You may be joining us from a jurisdiction such as the United States, England, wherever you happen to be joining us. Many of these issues are similar. And what we want to do today is launch a project which on March 3rd can bring together the ideas of the speakers we'll be inviting, your ideas, the ideas of your colleagues, to come up with some key foundation pieces for a court system, an approach to resolving disputes that better suits the people it has to serve, that better suits the conditions of 21st century. So we all know that reports over the decades have said that the justice system, including our courts, is too complex, too slow, and too costly for most of the people it's supposed to serve. We know increasingly our courts have, if not a substantial minority, then a majority of people who are not represented by lawyers. Most not by choice, but by circumstance. We know that in various jurisdictions, Ontario, for example, getting a trial can be a multi-year process. We also know that our judges and our lawyers and the other justice participants are working hard. You're working as hard as you've ever worked. You're working to make justice happen for the people that you represent or the people in the system. And we thank you for that. We thank you for the time you put in, for the extra effort you make. And we thank you for the years and years of work that you have done to try to serve even more people. This isn't about your individual work. This isn't about the individual work of the other justice participants. This is about the system itself. Do we have the system we need for today and for tomorrow? Do we have the system we need to represent 100% of the people? So where would you start on a project like this? You'd probably start with where we are. The phrase that I use, too complex, too slow, too expensive, is a phrase that came out of the Access Report 2013, an Access to Civil and Family Justice report. You'll remember, those of you in Ontario and Canada will remember then Chief Justice McLachlin set up an action committee to improve access to justice. And they authored a report in 2013. It talked about where we are in Canada and where we want to be. Their outline of where we are was pretty stark. They said, as I had repeated, what most users of the system experience, a system that just doesn't work as effectively for them as it should. They talked about how those who are not represented by a lawyer get a worse outcome, ranging anywhere, I think they said, from about 17% to over 1,000% less likely to get the same outcome as if they're represented by a lawyer. It's just mind-boggling. And yet we see increasing numbers of unrepresented litigants in the courts. They talked about how the legal needs of about 80% of Canadians are not being dealt with by lawyers, by the justice system. And they had a number of other statistics. They talked about a way forward. Now, that's just one report, but it does happen to be authored by a number of the legal leaders of the day. They made a number of recommendations. None of the substantive recommendations have been pursued with much apparent enthusiasm. It's a starting point. And there are others throughout Canada, throughout the decades, throughout North America and beyond, which have talked about what to do next, how to approach it. So what are we going to do? No, we're not going to boil the ocean. We're going to pick up a few key themes. First, we're going to talk about what happens before you actually enter the courtroom. One of the themes from the Access report was making sure people are aware of their rights, responsibilities, and having them undergo some simple triage even before they launch any form of action or proceeding, but certainly at the very beginning of it. It's that front end of justice. That's going to be January's theme. And we're going to come back in January for about 2 hours. We'll have some speakers, and we're going to bring that theme to the fore. We hope between now and then, you're going to fire your ideas to us at our Liz email, and Hirsch is going to remind me of the email by putting it in the chat function, because we want your participation. And we're also going to talk about transparency. You know, what gets measured gets managed. And there are a number of jurisdictions in the world which are transparent. How long does it take a case to go from beginning to end? How many days for the different steps? What are the bottlenecks? Why do things get adjourned? If we know what the problem is, we can start helping with the solution. You don't know what the problem is, well, there's not much you can do. February is going to be the next theme, and that's going to be what happens in the court process. So there's been a lot of talk over the last several months about redoing the rules. We heard that from the Chief Justice of the Superior Court of Ontario. Let's streamline the rules. That's an idea that's been around for, I'd say, many decades. It was one of my themes when I was Attorney General about a decade plus ago. We are where we are. What steps would you take to streamline the internal process, whether you're in Ontario, elsewhere in Canada, in the States, or somewhere else? What steps would you take? What are the key markers? And we're going to develop a little work plan to elicit your ideas so that when we come together in February, over again a 2-hour period, we can discuss your ideas, discuss some themes, and figure out where we go next. Can we kickstart this rule simplification process? We surely are beyond the talk stage. It's time for a bit more of the walk stage. We're going to bring this together in March with an in-person conference, and yes, the capacity for those who happen to want to attend virtually. If you haven't had your fill of virtual proceedings already, but we will be there in person on the Toronto Metropolitan University campus. And we'll be there to welcome you and bring these ideas together in one place and hash out an approach that we can forward on to the powers that be. Neither Hirsch nor I have any power, at least none that I'm aware of, to make the change instantly. Maybe some of you do, that's fantastic. But if you don't, let's at least put it together in simple form and provide it to our AG, the Minister of Justice, anybody else you happen to want to provide it to, and make it available publicly. But let's at least put some markers out there to get people moving in the right direction. Now, I don't think for a second that we're all going to have exactly the same idea on how to make things move better for the people that we serve. I don't think that for a second. And we welcome your ideas, whether they happen to coincide with what Hirsch and I think or anything else, with just one caveat. We welcome your ideas completely, with one caveat, and that is this: that traditionally, I've been around this for a few years, our first answer to many problems in law is one of more. If only we had more judges, more lawyers, and more courthouses, or other things, all of which are more money, it would work better. And we can argue from now till the next millennium what that means and whether there's been more, but we are where we are. And every government of every stripe over the past 20 or 30 years are going to be able to point to the investments they made, often on the promise that access would be increased and improved. And we are where we are, where it seems to be getting worse and not better. So this is not about more. This is the kickstart to better. The more conversation comes next. After you kickstart the process, then you figure out what you need, how you need it, where you would support the progress that's been made. I often say that money doesn't make leaders, but money finds leaders. If you show leadership, there'll be no shortage of money to come along and support the initiatives. So that's the simple approach. Rebuilding courts, it's from us up, it's our challenge. I see many of the names on here, people who have a lot of experience with the courts. We need your input. In a few days, we're going to send out the key dates, probably the beginning of next week. We're going to send out the key dates once we start confirming some of the speakers. So there'll be a date in January, which will be the front end and measurements. There'll be a date in February, which is the court process. And we'll provide more detail on March 3rd, the conference. We'll have a place where you can send your ideas, and we'll start engaging you in conversation and discussion on how you can make a difference through this project to the powers that be. That really is where we are. Where we are with this project. Our focus is going to be, not unnaturally, on the civil and the family courts, but we welcome ideas relating to any of the courts. I suspect the foundation pieces are pretty similar. So with that, if you have questions, comments, cries of anguish, fire them into the chat, and we will happily answer them, or at least try to. And carry on from there. Any questions? We, of course, have done a lot of work in technology and working with a number of very innovative tech startups, but and technology, of course, is going to be a major theme. You've seen some of the courts from the Zoom moment, beginning of the pandemic, which I call March 11, 2020. Started doing things with technology that many of us have been told we could never do. Oh, you can't do a proceeding using web conference or Zoom. It just, you can't. It's not possible. Parties can't participate. You know, your ethics will disappear. And we learned a lot during the pandemic. We learned that most of the reasons for no were not reasons at all. Now, at the end of the pandemic, we've seen, in some cases, a falling back rather than a leaping forward. That's unfortunate. We've seen people rushing back to the old familiar, which was fine if you were a client being represented and could afford to be represented by the old familiar. Not so good if you had one of the 4 out of 5 legal needs that weren't being assisted by the legal profession. So let's see if we can use technology or use new approaches that have nothing to do with advanced technology. It's just a different way of looking at it, some of which the Access Committee 2013 and the report outlined. So that really is what we wanted to talk about today. Today's the soft launch of that. You'll get more information at the beginning of the week. We really want you to participate. I want you to share this with your colleagues. See what we can come up with. Hirsch, any questions, comments, cries of anguish, anything that I've missed? If anyone has a, you can certainly send your questions after today to me. And Hirsch has provided liz@ryerson.ca. The email has the old name, even though the university has the new name.
Gary wanted to know, is graduated licensing part of the discussion?
Hey, let's, whatever you make part of the discussion will be part of the discussion. And if you, Gary, if you want to share a couple of thoughts on graduated licensing and how that should be part of it, by all means. We're probably more focused on what the individuals or businesses get by way of information, how they are triaged at the beginning, but who does that work would be a very interesting part of the conversation. In court, who gets to go to court? Who gets to represent the clients? I mean, I think that's a fantastic conversation. If 50, 60, 70% of the people are not being represented by anybody in court, what should we do to address that? And what kind of representation and how do we do that? Would that make it work better? Let's put everything on the table except more money.
And there's a question around, is this focused on civil, family, criminal? How are we differentiating?
So the focus of the Access report was civil and family. But let's make it the foundation pieces. If you provide people with information about their rights and potential remedies, that shouldn't be limited to any one particular area of law. If you provide people with a triage approach, recognizing that there are different rights and responsibilities and different charter implications for different areas of law, that shouldn't be limited to one. If there's some fantastic initiative, say in a state in the United States or a jurisdiction, maybe a civil law jurisdiction in criminal, well, why not talk about that and see if it could apply to family and civil proceedings here in Canada? Why not? There's no reason why not. Let's be broad-minded in our approach to this and come up at the end of the day, come up with some recommendations, some of which might be specific to an area of law. Others might have much broader application.
That's all the questions I've seen.
That's great. Well, thank you so much for joining. We'll give you back the rest of your hour, and we'll be in touch with you early next week. The Liz has a, and there's already a great a great message about agencies accepting documents by email. Is there a recommended path? You know what? There's going to be lots of great questions. This is how we make change. You know, start throwing everything into the pile, and we can start sorting it by themes. And as I say, January, the front end, February, the part of the process itself, March, we bring it all together. And I think if we start adding some of these specific comments to the pile, we're going to really uncover the broad themes that we need to make some progress. You know, I can just see on the names that I can see on the screen already. There's a lot of experience here. This is the process you work in. This is where you work, and you've all got great ideas for making it better. So let's get them out there. Somebody should hear those ideas. I think we should bring them together and get them heard. That's what we're going to do. Thank you so much for this, folks. Take care. Enjoy the day. Oh, Hirsch, when's our social? A
We
plug
are
for
having
us.
a holiday party the evening of December 15th.
I'll be there.
Yeah.
So will Hirsch.
and we
you're
will
all
send
invited.
invitation to everyone who attended today.
That's fantastic. Thanks, folks. Take care. Bye-bye.